An affidavit is a voluntary written statement, verified under oath, to be used as evidence in a court of law. Affidavits must be verified by the stamp and signature of anyone who is authorized to do so by law, referred to in this video as a taker of oaths, which refers to a justice of the peace, a commissioner for declarations, a public notary, or a lawyer. As with most legal terms, it is a medieval Latin word and means he has declared under oath. The person making the statement is called a deponent or affiant. A court cannot force a person to make an affidavit. It must be done so voluntarily by someone who has relevant knowledge of the facts pertaining to the purpose of the affidavit. Anyone can make an affidavit, so long as they have the intellectual capacity to take an oath or make an affirmation, and have knowledge of the facts of the case. This could even be a child, depending on the country, and the intellectual capacity of that child. Commonly, affidavits are provided by witnesses, of which there are three main types. An expert witness, which is a specialist who is educated in a certain area pertaining to the case. An eyewitness, who physically saw certain events and describes what they saw. Or a character witness, who knows or knew the victim, the defendant, or other people in the case, and can speak to their character, whether that be positive or negative. The document itself usually starts out with information about the deponent and how they are involved in the case. If they are a professional, it will also include relevant credentials. Unless they are an expert witness, their affidavit should contain only what they saw, heard, or experienced, rather than hearsay or opinion. They can also attach relevant exhibits, which have been referred to in their affidavit, whether that be photos, reports, text messages, video, audio, etc. In cases where the deponent does not want their private information to be public, they can request that their affidavit be sealed, which means that it cannot be accessed as public record, or that personal information be redacted, which means removing the information both physically and electronically, so that it cannot be accessed unless requested by the court. To swear an affidavit, the deponent and the taker of the oath will recite these or similar phrases. Phrases may differ from country to country or even state by state. However, the general phrasing is, "Do you swear that the contents of this affidavit are true and correct, so help you God?" To which the deponent will reply, "I swear that the contents of the affidavit are true and correct, so help me God," or simply, "So help me God." Both are acceptable. Were the deponent to not believe in a Christian God, or any God for that matter, they would affirm their affidavit instead of swearing it. This differs only slightly in process. Depending on the country, they may be allowed to swear upon their own religious text, for example the Quran. However, in most cases, it's easiest just to affirm, as it holds the same legal weight. The oath taker will say, "Do you solemnly, sincerely, and truly affirm and declare that the contents of the affidavit are true and correct?" To which the deponent may answer, "I solemnly, sincerely, and truly affirm and declare that the contents of the affidavit are true and correct," or simply, "I do." After the verbal swearing or affirmation, both parties will then sign each page where indicated. First the deponent, then the taker of oaths. The taker of oaths must witness the signature being written in person if they are going to sign in verification. They must also stamp their signature with their identification number, in case the verification of the document comes into question. The taker of oaths does not need to read the affidavit, nor have any knowledge of the matter. They need only to confirm that you are who you say you are, usually done by taking a photo ID, and that you are signing on that day in front of them. Once the affidavit is filed in court, it cannot be withdrawn. If someone were to knowingly lie in their sworn or affirmed affidavit, they would have committed perjury. The punishment for perjury differs from country to country, but in some, it can carry a prison sentence of up to 10 years.